Okay, welcome to week 6, week 6 of the CRW2601 online lecture. We are covering study unit 7 in week 6, and that will be the study unit dealing with culpability and criminal capacity. But before I proceed, I just want to make some few house rules for your convenience. Can I firstly state that for those students that are having NSFAS challenges and have registered later than usual, some possibly even after their first assignment due date, please note that the assignment portal is still open until the 7th of June for you. So there should be no reason for you to be unable to submit an assignment. We strongly encourage you to take the opportunity to submit your assignment. I think for your sake, I will communicate that it is based on study unit 4 in the study guide. So that will just make it easier for you to go and refresh or familiarize yourself with the contents of that study unit. Furthermore, please note that there are online lecture recordings for study unit 4. That would be, I believe it is week 3 of our online lecture schedule. You will find study unit 4 under week 3, under announcements, both the slides and the recording for your convenience. So you are encouraged to work on assignment and submit it. Please, for the students that have been identified for the early completion program, that is the ECP students, please be on the lookout for an announcement under your sites about further teaching interventions that we will conduct for you given your early schedule. With those two remarks aside, let us get into the content. Now, to recap, as we always do every week, I'd like to thank Professor Molema for covering last week's unit, which was unlawfulness 2. But we have done so far on week 1, chapters 1 and chapters 2 combined. On week 2, we did the act and omissions. On week 3, we covered definitional elements and causation. On week 4, we covered unlawfulness 1, covering private defense and a general understanding of what the concept of unlawfulness means. And on last week, Professor Molema covered unlawfulness 2, which covered the rest of the grounds of justification. So this week, we are dealing with culpability and criminal capacity, and we are starting from page 99 of your study guide. So those of you who've got the study guide and are perusing through it, you can follow also the lecture and its contents by looking at page 99 onwards. Just a brief recap. Unlawfulness, we said that it was without justification or an understanding of it, is that although someone can perform an act which complies with the definition elements of the crime, it may not be enough to make that person criminally liable. There are still two other elements, namely unlawfulness and culpability, which still must be satisfied before we can say that somebody is criminally liable. The unlawfulness just means conduct is unlawful if it conflicts with the boni mores. And we spoke about the grounds of justifications over the last 2 weeks, covered private defense, And then after last week, Professor Molmar covered the rest of the grounds of justification, being necessity, consent, presumed consent, obedience to orders, official capacity, and triviality. And you are also informed not to study the right of chastisement, given the developments in the recent Constitutional Court judgment regarding that defense. So now, as you can see, we are systematically moving across all the four general elements of liability. Today, we're going to cover culpability. In fact, we're going to introduce it because culpability is such a condensed topic that it requires a few more study units to explain and to understand and to unpack. So for this week, we'll be covering culpability and understanding of what it is, and then we'll cover the general defense of criminal incapacity, also referred to as non-pathological criminal incapacity. Next week, we will cover the other two defenses excluding criminal capacity, being mental illness and youth. And then following from there, we'll get into intention for the next two study units. And then we'll speak about negligence in the next unit. And then in unit 12, we will cover the effect of intoxication and provocation. And then culpability ends ultimately with unit 13, which we will inform you don't need to cover. You don't need to study unit 13, but we'll repeat that and emphasize that as we go along. So today we are focusing now on culpability. What is culpability? We have covered so far the act and looking at the concept of an unlawful act. So criminal liability, if you read the textbooks, comprises of two broad requirements. What's called the unlawful act, or in other textbook, it's called the actus reus. And then the other element is culpability, which in other textbooks is called the mens rea, or the blameworthy state of mind. So far, we have focused on objectively assessing whether the act complies with the requirements of liability and whether that act is unlawful, meaning there's no ground of justification to exclude that person from the conduct being unlawful. So having done that, we are now asking ourselves, did X commit the unlawful act with a blameworthy state of mind? And that is where the concept of culpability comes in. We must have grounds upon which we can hold X liable and say that X committed this with a certain mental awareness or mental ability, a certain knowledge, and certain aptitudes that are unique to X. So that is what culpability is looking at as a concept. We want to hold every person who commits an unlawful act blameworthy. So that person must commit that with a certain mental ability or mental awareness and with certain knowledge. This is where we look at two concepts or two legs of culpability, being criminal capacity and either intention or negligence. Now, criminal capacity is the foundation upon which we base any assessment of blameworthiness, and it speaks to X's mental abilities. There are two abilities that X must have before we can even look at whether X acted with intention or with negligence. Those two mental abilities are the ability to appreciate the wrongfulness of his conduct and the ability to act in accordance with an appreciation of wrongfulness. We'll get into that concept when we get into the meat of criminal capacity. But before we get to that aspect of criminal capacity, let's speak about the principle of contemporaneity. This is the principle basically that says that the unlawful act and the blameworthy state of mind must coexist at the same time before we can hold X criminally liable. X cannot perform the unlawful act innocently without an awareness that it's unlawful. And at the same time, X cannot simply have the intention to achieve something, but not perform the unlawful act at the same time. So the interesting case that you have there is Masilela. In this case, X burgled Y's house, assaulted and beat Y up. At that time, he had intention to kill Y, but did not succeed in killing Y because Y just became unconscious from the beating. Then whilst the body of Y was lying on the bed, X decided to ransack the house and take a couple of things, and then afterwards burnt the house down. The post-mortem revealed that the house, the burning was the cause of his death. So at the time when he was assaulted, X had intention to kill, but did not achieve the killing because Y did not die. But at the time when he burnt the house down and Y died because of the fumes, X did not have the intention anymore at the time. Because how can you intend to kill what you believed was already a corpse? So interestingly, the Supreme Court of Appeal decided that, well, we can't accept the argument that was presented that there were two acts. The first act happened with intention but without the unlawful conduct. But then the second act happened with the unlawful conduct having been achieved but no intention. The court said we should look at this as one single course of conduct. So that's the interesting case of Masilela, which we present to you as an exception to the general rule that both the culpability and the unlawful act must exist and occur at exactly the same time. What is criminal capacity? As I have indicated, definitions are important, so you must make sure that you know this definition and you understand it. A person acts with criminal capacity if they have the mental ability to firstly appreciate the wrongfulness of his or her act or omission and act in accordance with such an appreciation of wrongfulness. We refer to the first leg of criminal capacity as X having certain insight or certain understanding. It is the cognitive aspect of X. And then we refer to the second leg of capacity as being the aspect of self-control or self-resistance, the ability to act with a certain understanding. That's the cognitive leg of criminal capacity. These concepts are explained for you on page 104 and 105 of your guide in more full detail. In fact, from 104 until 106, that's where you understand these two legs and they're explained to you. Now, there are things that I want to highlight for you in that portion. Can somebody switch off their mics, please? I hear an echo. There's a difference between mental abilities and knowledge. And I think this is important for me to stress and help you to understand. Criminal capacity focuses on X's mental abilities. These are aptitudes or abilities that are expected of all individuals that are to be held to account for a breach of the law. So, for example, you can't hold a mentally ill person who acted motivated or driven by their mental illness. You can't hold them to account because they don't have the ability to appreciate the wrongfulness of their act or omission. You can't hold with the same logical reasoning certain children under a certain age. So children, for example, under the age of 7 years are presumed not to have capacity because they don't have the mental ability, the aptitude to appreciate the wrongfulness of their conduct. So criminal capacity refers to mental abilities, whereas intention, which we'll cover later on, focuses on knowledge or awareness, someone's state of mind when performing the unlawful act. That's the focus of intention. Now, students sometimes confuse the second leg of capacity, which is the cognitive leg, the ability to act in accordance with an appreciation of wrongfulness. They confuse it with let me rephrase that. Students confuse the first leg of capacity, which is the ability to appreciate the wrongfulness of their act or conduct, with what is called a mistake relating to a ground of justification or a mistake relating to unlawfulness. So let me explain what I mean. When we look at the ability to appreciate right from wrong, we are talking about a foundational mental ability that should be presumed upon everyone who acts in an unlawful way. But when we talk about an awareness or a mistake relating to unlawfulness or a mistake relating to the presence of a ground of justification, where X thinks that they are acting in private defense, for example, or where X thinks they are acting in with consent or in necessity, that is putative defenses. So that is called a mistake relating to a ground of justification. In that instance, that is an assessment of X's awareness when he acted. It is an assessment of what was X aware of. Was X aware that what he or she was doing was unlawful? That can only be assessed at the time when X actually acted. What did he perceive? How did he see the situation subjectively? So make sure that you don't confuse those two concepts, the ability to appreciate wrongfulness and what is called mistake relating to a ground of justification, which we'll cover when we deal with intention. Just to also indicate something that I did not emphasize a lot, but is covered at unit at page 101. It is that the assessment of culpability is subjective, whereas the assessment of unlawfulness is objective. This is very important. These two concepts are important for you to remember, that when we look at unlawfulness, when we look at whether X acted in private defense or X acted in necessity or X acted in consent, we are assessing X's conduct against requirements that are given by law. That's why the assessment is objective. We are not concerned about what he thought or what he perceived the situation to be. But the moment we talk about culpability and we assess whether X acted with culpability, we are now assessing what X perceived, what X was aware of, though that his subjective state of mind becomes key to understanding whether he can be held blameworthy for his or her conduct. So bear in mind that an assessment of unlawfulness is always objective, whereas an assessment of culpability is subjective. Coming back now to the defenses that exclude criminal capacity. We are now on page 106 of your guide. You will see a beautiful diagrammatic illustration of the defenses that exclude criminal capacity. Now, today, we're going to cover the third aspect that you are seeing on the slide here, the aspect of non-pathological criminal incapacity, otherwise also called the general defense of criminal incapacity. And then next week, we'll cover the two specific defenses that exclude criminal capacity and which are governed by legislation, that being mental illness and youth or youthful age. Those we will cover next week, but for now, just note that there are three defenses that exclude criminal capacity. As I stated, today we're going to focus on the aspect of non-pathological criminal incapacity, or NPCI. I want to caution students that although we allow you to abbreviate it as NPCI, we want to stress that you have to spell it correctly. Don't do something like NPIC or NCPI. It is NPCI. So although we give you leeway to abbreviate it as NPCI, please do not take liberties with it and misspell it. It is non-pathological criminal incapacity. And the other thing that students also tend to forget is that last word is incapacity. So it's not capacity, it is incapacity. So it's not non-pathological criminal capacity, it's non-pathological criminal incapacity. Now, the word pathological is important to understand here. When we say something is pathological, we say that the incapacity arises as a result of an illness of the mind, as a result of a pathological disturbance, a mental issue. So the word non-pathological is meant to distinguish from mental illness. So mental illness is a particular form of defense. It is it's where the incapacity arises because of a pathological state of mind or an illness of the mind. That is what mental illness is. But when we speak of instances of non-pathological criminal incapacity, we're speaking of instances where X does not suffer from a mental illness, but for a relatively short period of time, when he or she committed the act, he or she did not either have the ability to appreciate the wrongfulness of their act or omission, or the ability to act in accordance with an appreciation of wrongfulness, either as a result of factors like emotional collapse, intoxication, provocation, fear, shock, anything that can affect those two legs that is not related to mental illness. Those are non-pathological disturbances that can affect the two legs. Now, before we get to the important case of ED, which you have to study for exam purposes, and you have to understand what it held, it is important that you understand the development of the defense of non-pathological criminal capacity. It developed in the 80s and the 90s through cases like Lobsher, Kampfer, and Weed. And the courts made a clear distinction between criminal capacity and involuntariness. They were able to make that clear distinction between the assessment of mental ability and the assessment of bodily movement. So at that time, the defense was really successful, and it was growing in prominence until 2002, when the case of ED came into being. In that case, X, being a hockey player, had his hockey stick in his car, but was at a social function. And at this social function, X and his wife were drinking or enjoying a good time. And then at night, while returning home, X was driving, Y came with his car on behind him with bright lights on and overtook X, and then began slowing down. And that frustrated X so much that he eventually overtook Y and tried to speed off to get away from Y. Y sped towards X at high speed again, lights on bright, and again overtook X. And then after overtaking X, slowed down, and X became frustrated. X decided to overtake Y again, but this time he stopped by the side, and Y then stopped by the side as well. X got out of his car, picked up the hockey stick, smashed the windows and the car doors with the hockey stick, dragged Y out of the car, and assaulted Y until Y died. So it's a case of road rage to an extreme, if you can say. So you can call it the road rage case just to remember it. Now, in court, X raised the defense of saying that his psyche was so disintegrated from provocation and emotional stress that he could not act in accordance with an appreciation of wrongfulness. He could not control himself. So in other words, X was saying, as a result of provocation and emotional stress, I could not fulfill the second leg of capacity, being I could not act in accordance with an appreciation of wrongfulness at that time. Now, the SCA, in a very detailed judgment, observed the situation and passed decided cases on this aspect. The SCA felt that in many of those previous cases, the account of the accused was simply accepted as gospel, so to speak. So the courts did not make, according to the SCA, the courts did not make a thorough assessment of whether the account of the accused accorded with ordinary human experience. And so ultimately the court reached a decision which is rather controversial. It stated that where X alleges that they did not have the capacity to exercise self-control as a result of provocation or emotional stress. Basically, they are saying that they could not subject their bodily movements to their will or intellect. In other words, they could not act voluntarily. So ED collapsed the distinction between the second leg of capacity and the element of sane automatism, and said that there's basically no distinction where X alleges that due to provocation and emotional stress, I could not control myself, and the allegation or the argument that I could not subject my bodily movements to my will or intellect. So this is what we suggest going forward in terms of your understanding of ED. ED is a very important case for you to understand, in the sense that the court said that cases of provocation and emotional stress should be treated as cases of sane automatism. And as we know, as we have covered before, people don't succeed easily with defenses of sane automatism. It is very, very difficult for you to allege that you could not control your own bodily movements when you committed the criminal act, especially if we're talking about provocation and or emotional stress. But in other cases, such as where intoxication or a combination of intoxication and other factors affect capacity, that the defense of non-pathological criminal capacity still remains and still exists. All right, that is the end of your study unit 7 and week 6 online lecture. I will let me just check a few things before I continue here. Okay, all right. Just to tickle your fancy, those of you who watched the Oscar Pistorius case, and those of you who are able to access the High Court judgment of the Oscar Pistorius case, when you read it, I would really encourage you to get it for yourself, read it at your own leisure. It is a very, very interesting case. But what was interesting is that in that case alone, Mr. Pistorius raised 3 different defenses, which was noted by the prosecution advocate Gerinel. At first, he said that the gun just went off, which is effectively an argument that I could not control my bodily movements or subject my bodily movements to my will or intellect. In other words, I acted involuntarily. That was his first defense when he was on the stand, that is. And then secondly, he raised what appeared to be a defense excluding criminal capacity. You will recall that at some point he was taken to Viscopies to be assessed by psychiatrists and psychologists. They came back and said that no, at the time he acted, he had both the 2 legs of capacity. They were there. So he did not lack criminal capacity at all. But part of his argument as well, or the argument that was raised on his behalf by his advocate Barry Rue, was that he had a heightened anxiety disorder that caused him to have what was dubbed a fight response. So in other words, because of his anxiety, he was triggered, and in his triggering, he could not exercise self-control when he fired those shots at the door. So that is an example whereby he raises a non-pathological criminal incapacity as a defense at that time, but the court did not buy it as well. Finally, he eventually rested, and the case ultimately rested on putative self-defense or putative private defense, which we'll cover later on in the units dealing with mistake. But I want to just express and share that particular case to alert you to the fact that non-pathological criminal incapacity was indeed raised in that case, and it was just interesting how the courts handled it. Okay, so I will now proceed to put the slides down and attend to your questions. Can I ask that you raise your hands up, and I will unmute you and allow you to speak. I also want to stress that for those who put questions in the comment, please note that we will, or I will spend time looking at them and giving a response to those questions as well. So if you have questions and you prefer to write them in the chat, please take the liberty to do so. Your questions will be answered. For now, I will proceed to take those students who have raised their hands up and would like to audibly raise questions. Let me also state as well that under the discussion forum on my UNISA, there's a section whereby you can ask your lecturers, and we have divided each study unit. It has its own section there. So if you have any questions that you want to pose, or if you are working along the material yourself, and as you go along, you've got some questions that you want to ask, please post them on the discussion forum. We check them every day, and we will definitely proceed to answer them. So for now, let me take those questions that are coming up. Retabile. Retabile Kamugelo, can you unmute your mic? Retabile Kamugelo. Kamuhelo. Okay. All right. I will take Shivam Haralal. Shivam, can you unmute your mic, please, and ask? Hello, Shivam. Can you unmute your mic and ask the question, please? Can I just ask students to switch off their cameras for now? And I also want to ask that students be patient, because for some students it takes a long time just to unmute their mic. So I request your patience with Shivam. If you are able to unmute your mic, please do so. We'll come back to you. Snegugu. Hello, Snegugu. Snegugu, can you unmute your mic, please?
Hello.
Hello. Hello, speak.
I want to ask Oh, I just want to start my module on the 21st of May. As assignment 1 is closed, what can I do?
All right, thank you for that. Please, students, I want to stress that all of you who have registered or had delayed registrations because of delays in payments, NSFAS payments and all that, the submission portal on my UNISA is still open for you until the 7th of June. Please proceed to do your assignment, which is based on study unit 4, definitional elements and causation. Please submit your assignment before the 7th of June. Does that help?
Yes, thank you.
Okay. All right, please mute yourself.
Okay.
Yeah, please mute yourself. Okay. Then I'm going to take David.
Thanks, Prof. Good afternoon. How are you?
I'm well, thank you.
I'm fine, Prof. I think it should be a quick one with regard to the non-pathological criminal incapacity.
Yes.
Will I be?
Will you be
Fair and honest to myself, or even to the second pen? Will I be fair to myself when I'll be saying the non-pathological criminal? It's something is related to something that happens for a temporarily situations.
Yes, it is. It is an argument that temporarily, at the time when the crime or the unlawful act was committed, I did not have criminal capacity, and my lack of capacity was based either on emotional stress, shock, anxiety, intoxication, or any other factor that is unrelated to mental illness.
Oh, okay. No, thank you very much, Prof. It makes perfect logic. Thanks.
All right, please mute yourself. Okay, there is a person by the name of M. Just M for Mike, for Mary. Can you unmute yourself? Hello, M.
Hi, Prof. Can you hear me?
Clearly.
Okay, so good afternoon.
Afternoon.
I raised my hand to ask you if you could please repeat your explanation on unlawfulness, which equates to objectiveness, and culpability, where you talk about subjectiveness. I didn't get your explanation there, and you did tell us to take note of the difference between the two.
All right, thank you very much for that question. Let me refer you to page 101 of the study guide, and that is for the benefit of all students, where we briefly explain the difference between inquiring into unlawfulness and inquiring into culpability. Remember, as far as the steps of investigation, unlawfulness comes before culpability. So when we assess whether X's conduct was unlawful, that is, whether we assess whether he can rely on private defense, necessity, or consent, we are assessing whether his or her conduct satisfies requirements, certain requirements that are given in law. So the assessment is objective in the sense that we are assessing whether his conduct measures up with those requirements. We're not concerned about what X thought or what X perceived the situation to be. So to give you an example or a practical example of that, there's a difference when I say in court that I am alleging that I acted in private defense and therefore my conduct was not unlawful. And then I say afterwards, if that defense is not successful, I thought that I was acting with private defense. I thought that I was in a situation of private defense where my life was under threat and I acted. Those two assertions are two different defenses. The first assertion is to say that I did not act unlawfully. But if that assessment fails, then I'm saying that I thought I had a right to defend myself, and therefore I lacked the intention to act unlawfully. So those are the two examples I want to explain to distinguish between the inquiry of unlawfulness, which is objective, and the inquiry of culpability, which is subjective.
Thanks, Prof. I'm covered. Thank you.
All right, it's a pleasure. Please mute yourself. Tsulu, may you kindly unmute yourself? Tsulu? Tsulu? All right, okay, I will take then Cynthia Mashele. Cynthia Mashele?
Hi, Prof. Can you hear me?
Hi.
Actually, just wanted to ask a question regarding the Masilela case. I wanted you to go through it again and explain, because I didn't understand where you said X tried to kill Y, but Y didn't die from the strangling or the beating, and then when X set the house on fire, that's when Y died. And then the judgment, I didn't understand the part of the judgment.
Okay, all right, no, good question. We use the Masilela case as an example of explaining contemporaneity, the principle of contemporaneity. You'll see it discussed on page 102 to 103 of your guide. Now, the principle simply says that the unlawful act and the culpability must exist at the same time. So at the same time when the unlawful act is committed, there must be culpability. There must be a blameworthy state of mind. Now, in Masilela, what happened is that there was an exception to that principle, apparently, because on the one hand, Y was assaulted and beaten with the intention of killing him, of being killed. So he was beaten by X with the intention of killing him. But that was not successful because Y did not die as a result of the beating. Y was simply unconscious. But then afterwards, after X had ransacked and stole items from the house, X decided to burn the bed and to burn the house down. And the autopsy revealed that Y died as a result of the fire and the burning. Now, you can already imagine at the time when X had the intention to kill Y, there was culpability, but there was no unlawful act there in the sense that there was no causing of death for the purpose of murder. So death was not caused at that time, even though X had the intention to kill Y. However, at the time when X decided to burn the house down, that caused the death. So the unlawful act was present, but X thought that Y was already dead. So the intention to kill was non-existent at the time. So, however, the Supreme Court of Appeal decided not to accept the argument on behalf of X that because the unlawful act and the culpability were not contemporaneous or did not happen at the same time, because of that, X must be exonerated from being held liable for murder. They held that all these events consisted of a single course of conduct where the intention was existent all along. Is that clear? Hello, Cynthia?
Very clear. Very clear. Thank you very much. I understand.
Okay, it's a pleasure. Can you mute your mic, please? Thank you. Mandisa? Mandisa, can you unmute yourself? Hello, Mandisa. Can you please unmute yourself? Okay, I will proceed to take Odwa, but if anyone whom I have passed is able to unmute themselves, because I can still see hands up from Shivam and from Mandisa. If your hand is still up and you can unmute yourself, you can proceed to do that. Even Tsolo, opportunity is still available for you to unmute yourself. If you're a hello.
Hello.
Yes, Tsolo.
Yes. Prof, I don't know if I understood you correctly when you are saying that in the Masilela case, when he assaulted and beat X, the act was not seen as unlawful. I thought that action is unlawful on its own, the beating and the assaulting. I don't know if maybe I didn't understand you correctly.
Okay, no, let me explain. Thank you for asking. It's a fair question. When we speak of the unlawful act, we are talking about the killing, because it was X was charged with murder. So obviously, facing a charge of murder, the unlawful act consists of the causing of death of another human being unlawfully. So when X beat Y and assaulted Y, it did not result in the death of Y. So for the purpose of murder as a charge, the unlawful act was not existent. Do you understand?
Yes, now I understand. Thank you.
Okay.
Thank you.
All right, please mute yourself. Thank you. Okay, let me take Odwa. Odwa, can you unmute yourself, please? Prince, can I ask you to switch off your camera? Thanks. Hello, Odwa.
Hi, can you hear me?
Hello, Odwa.
Can you hear me, Prof?
I can hear you.
Okay, my question actually it's more of seeking clarity, or I'm curious about this. Within the Oscar case, you mentioned that one of the facts were put that maybe Oscar had heightened anxiety. I'm referring to the non-pathological criminal incapacity defense. So if it were be that Oscar was previously diagnosed with an anxiety disorder, would it then not be under non-pathological and be under mental illness, and it would be something that he could actually put at his defense? And the fact that he wasn't actually previously diagnosed with it puts it under non-pathological, and it was not giving him such a good standing. I don't know if you understand my question.
I completely understand your question. Yes, indeed. Look, if there is a level of anxiety that can be recognized in the psychiatrist books as a mental illness. So if that is the case, then his defense would be mental illness. It would not be non-pathological. But given the state of affairs that he was in, he raised a general anxiety.
Okay.
Yeah, which is a factor that is not related to mental illness.
Yes.
Yeah.
Yes.
So that's why it was said that his anxiety causes him to act in a fight response.
Yes.
And in acting in a fight response, he couldn't control himself. He was triggered. So on that basis, it was a defense of non-pathological.
Totally understand. Thank you so much, Prof.
Pleasure. Can you mute yourself, please? Thank you. Gertrude. Gertrude. Gertrude, please unmute yourself. Okay, let me proceed now to check at the chats. The chats, all right, let me just sort out the screen here. Okay, I will read the chats for the benefit of everyone, and try to answer what is still left outstanding.
Can you hear me, Prof?
I can hear you.
Yeah. Okay. My question was on the non-pathological criminal incapacity on the ED case.
Yes.
Okay, then they say that his defense was one of the temporary non-pathological criminal incapacity resulting from a combination of severe emotion, stress, provocation, and a measure of intoxication. So at the moment, he could not differentiate between wrong or wrong. I mean to say right or wrong. So it's possible that in extreme emotions such as anger following the provocation may be strong, that ED at the time lacked criminal capacity. So can the court prove that ED at the time of the provocation suffers such emotional instability to appreciate the wrongfulness of his act? According to the appreciation, he should not be found guilty of the crime. Like maybe they could have called the psychiatrist or the psychology to assist him and report the findings to the court, like they did on the Oscar Pistorius case. Like this whole case just confuses me. I've been trying to go through it the whole day, but I still don't understand it.
The ED case?
Yes, the ED case.
No, okay. In ED, his defense was to say that his psyche was so affected by provocation and emotional stress,
Okay.
that he was unable to act in accordance with an appreciation of wrongfulness.
Okay.
In other words, he did not have self-control. That was his defense.
Okay, but they were saying on the case that he was drinking alcohol, so at some point he was intoxicated.
Well, he wasn't intoxicated. I think it was found that the level of his intoxication did not have an impact on his conduct. He was more provoked and under huge emotional strain.
Okay.
Than was the case with the drinking. So the drinking, despite the fact that he did drink, he did not drink to the point that it would have affected or contributed as much as the provocation and the emotional stress caused by the other driver and the rage.
Okay.
Yeah.
Well, I understand it. Okay, thank you.
All right. Okay, I see a lot of questions about efforts to try to open PDF. I think Professor Mollema has covered that already. My colleagues are on hand to attack that. So Joanne asks, so if a person is drunk, intoxicated, can they be held liable for their actions? Rape, murder, etc. Joanne, good question. In study unit 12, we cover the effect of intoxication on the elements of criminal liability. And one of the elements that can be affected by intoxication, depending on the degree of intoxication, is criminal capacity, which we briefly introduce here under non-pathological criminal capacity. So based on what we'll cover in Unit 12, you will discover that a person can be so drunk as to lack either voluntary conduct, if it's very severe, either lack criminal capacity, if it's less severe than that, or even lack intention. So that's the short answer to your question, but we will cover that when we get to Unit 12. All right. Thank you, Professor Mollema, for covering that. Mildred asked an interesting question, says, my understanding is that it must be established whether the person was drugged by other people. What Mildred is talking about is involuntary intoxication. Now, involuntary intoxication, this is the situation whereby your drink is spiked, or for some reason, because of something that was that you took without any intention of being intoxicated, you became intoxicated, and in that state you committed a crime. That is a complete defense in our law. So if, for example, you were drugged or your drink was spiked, and in the midst of that involuntary intoxication, you committed a criminal act, you will not be liable because that is a complete defense. Can a person with multiple personality disorders be held liable for any unlawful conduct? Nakedi, thank you for that question. There's the case of Kavin, which you will see when we cover Unit 8. In that case, Mr. Kavin had a personality disorder, or had gone through so much in his life and was suffering from a recognized mental illness, gradual disintegration of the personality. and having diagnosed it as a certain mental illness, Calvin was found not guilty as a result of mental illness, and was treated at a psychiatric ward. So indeed, personality disorder, multiple personality disorder can be a mental illness. Okay, how do you prove NPCI? Does it need some form of psychological evaluation? Thank you for the question, Tandeka. The defense, okay, remember one thing, the onus of proof always is on the state to prove criminal capacity. So proof of criminal capacity is upon the state to prove beyond reasonable doubt. But the defense has an opportunity to call upon a psychiatrist or a psychologist to present evidence that demonstrates that at a certain time, X suffered from a certain temporary disturbance of his faculties, either the ability to appreciate right from wrong or the ability to exercise self-control. So it would be the defense who would bring across psychiatric evidence in court to establish non-pathological criminal capacity. Sunay says, Prof, if a person has been diagnosed with a mental illness, such as bipolar disorder, but has been on treatment for many years and is actually normal because he or she is on the right medication, can you still say he lacks criminal capacity due to mental illness if he commits a criminal act because he knew exactly what he was doing? Sunay, that's a very good question. The important thing that you will learn when we cover mental illness is that the existence of a mental illness on its own does not mean that you have a defense. The question is always, did that mental illness affect any of the two legs of capacity? So it must be established. So even if a psychiatrist comes and says, yes, this person suffers from a recognized mental illness, the court still has to make an assessment of whether at the relevant time, did that mental illness affect any of the two legs of capacity? That will be for the court to decide. The psychiatrist and the psychologist can only go so far. Thereafter, they leave it to the judge to make that assessment of whether the bipolar disorder at the relevant time when the unlawful act was committed affected any of the two legs of capacity. All right. Thank you, Prof. Mollema. You have covered that very, very well. Prof, building on previous study unit, if it is found during inquiry on unlawfulness that the grounds of justification is accepted as a defense, then we don't need to inquire on culpability any further. That is indeed correct, Sunay, because unlawfulness would be the leg where the inquiry ends, because X would escape liability because he or she did not act unlawfully. All right. Okay. there's a question from Sune again. Prof Masilela, or Prof or regarding Masilela. So X was not guilty on murder, but guilty of assault. No, actually, Sune, X was found guilty of murder because the court held that his throughout the entire conduct, both the act of assaulting and the act of burning or arson, the intention was present throughout. So it consisted of one continuous single course of action. The purpose we raise Masilela for you is to illustrate this concept of the unlawful act and the culpability must exist at the same time. That is the purpose for which we use Masilela as an illustration of an apparent exception whereby at the relevant time there was no coexistence of the unlawful act and the culpability. Pilasande says, where would developmental delay fall under? NPCI or youth, once unlawfulness has been established in terms of culpability? Okay, when we cover the defense of youth, Pilasande, you will recognize that the Child Justice Act regulates according to certain arbitrary ages, presumptions of capacity. So a child who is 7 years and below 7 is presumed not to have capacity at all. And that presumption is irrebuttable, meaning that the state does not have an opportunity to rebut that presumption. Sorry, I think it's until 10 years or something like that. Sorry, I just need to refresh that. I think it's up to 10 years, and then between 10 and 14 years of age, if a child commits a crime between 10 and 14 years of age, the presumption is rebuttable, meaning that the state has an opportunity to rebut the presumption of incapacity. All right. Mandisa says, okay, I will engage next time. I wanted to touch on contemporaneity relating to Masilela, in that if Masilela had left the scene and came back after a few minutes, then contemporaneity would have applied since the chain would have been broken. The issue there is not causation as such, Mandisa. The issue there is about intention. We will cover in Unit 10, when we do mistake, there is a particular form of mistake called mistake relating to the chain of causation. Under certain circumstances, it is possible for X not to be held liable if what he had foreseen would be the cause of events differed substantially from what actually happened as the cause of events to his death, to the death of Y. I don't want to confuse you at this stage, but the key is that when you're charged with murder, it is also important that the causal sequence of death be fairly foreseen by X. It should not be a case of, for example, X slaps Y, and then Y slips and falls and hits his or her head on the corner of the bathtub or on some sharp object and dies. In that instance, X would not have foreseen that by slapping Y, he would be causing Y's death. That is an example whereby the causal events of death could not have been foreseen. Can someone who is suffering from bipolar use that NPCI? Amile, yes, but there is bipolar disorder. To my knowledge, there are categories of it that fall under recognized mental disorders. So if it's a disorder that is recognized by psychiatrists, then it would actually be a mental illness, not a non-pathological instance. Oh yes, and Shane has answered you correctly on that one. So well done, Shane. Sunay says, if court accepts that there is no criminal capacity due to X suffering from a mental illness, the end result will always be admittance to a psychiatric hospital, correct? You won't go to jail, but you'll go to a psychiatric institution. You will see when we cover that unit, Sunay, that there are a variety of orders that the courts can give. So it's not just a question of the psychiatric institution, but definitely there will be a process of evaluation. Rulane says, Prof, is there a difference between intention and motive? Yes, Rulane, there's a difference between intention and motive. I mean, let me take an example. Somebody may steal something for the purpose of meeting someone else's need. The fact that the motive seems to be honorable and benevolent does not mean that X did not commit theft, because he certainly had dolus eventualis, if not direct intention to commit theft. So the motive is irrelevant to considerations of intention. Thank you, Mandisa, for the compliment. We really do appreciate your participation, everyone concerned. And I want to also take this time to thank my colleagues as well, Professor Molema, Professor Dean, Advocate Kumwenda, Ms. Baloy. Thank you, colleagues, for your participation, your presence, and what you do for all of us. We work as a team. Cheryl says, so it would not be wise for a defense attorney to use NPCI as a defense if there is another defense the attorney could have used in the ED case. I want to make sure that I understood your question, Cheryl. I would say that as a defense attorney, obviously, any defense that is available to use, you are well within your rights to use it if it's applicable. I mean, in the Pistorius case, Advocate Barry Rue, went all out as far as trying to salvage the performance of Oscar Pistorius on the stand by trying to raise the possible defenses that Pistorius may have been relying on. I mean, at first, he raised the issue of involuntary conduct. Secondly, tried the issue of absence of criminal capacity. And then finally tried the issue of putative prior defense. So as a defense lawyer, you can raise a number of defenses in the alternative. Comfort, as I said, motive and intention are different. One can have a motive that is that is benevolent or that seems to be noble, like maybe stealing bread, you know, in order to feed someone or to not go hungry. But at the end of the day, it still will not exonerate X from liability if charged with theft, because he had direct intention to steal, or at the very least, he foresaw the possibility that he would be, by doing this, he is stealing what is movable corporeal property that belongs to another, but nevertheless proceeded, you know, regardless of that. So he had dolus eventualis. Motive and intention are different. The final question is from Cynthia. Edie's defense was not accepted. Edie was found guilty. Thank you, Professor Mollema, for covering Comfort's question. Comfort, please see the response from Professor Mollema on that. Mandisa, I think it was the prosecution more or less that was frowning upon the multiple defenses, not so much the judge, as I remember well. But I think the issue is that if you are a prosecutor, your aim is to prove that the defense's contention does not hold merit. So you would try to prepare a defense, or you would try to prepare a form of attack that would ensure that the defense cannot rely on what it's relying on. So if the defense keeps on shifting the goalposts, it makes your life difficult as a prosecutor in preparing how to respond. So I think that's the only part where there was a frowning, not so much that a number of defenses were raised. All right, students, I want to thank you once again for an excellent participation in this lecture. I want to encourage you once again to post your questions as you go through your study material. You are welcome to write under the discussion forum your questions under the relevant study unit as you go along. We will be there to answer your questions on the platform to make sure that not only you benefit, but every student that visits the discussion forum benefits. If there are any particular challenges that students are still facing with their submission of their assignments, we are available. Please write an email to us. We are available to assist you in that respect. I want to thank my colleagues once again for participating in this process, and thank you all. Have a good day. Next week, we will cover Unit 8, which deals with mental illness. All right, thank you. Okay, I see some hands. All right. Okay, let me take these final two hands. I will indulge them. Lituma Bosaleti. Lituma Bosaleti, do you have a question? Tabile Mahlangu, do you have a question? Hello?
Can you hear me?
Yes.
Okay, just out of curiosity, I just wanted to ask if someone is diagnosed with amnesia, can they use the NPCI as a defense?
I'm laughing because yes, I'm not saying they can use it, but I am saying that there is a case. There are cases whereby a lot of accused people run to amnesia, or run to say that I just lost it. That's the common expression. I didn't know what I was doing. I lost it. That is unlikely to fly, even though it is usually the last line of defense that accused people who do not have anything to clutch on tend to run to. But in the end, the question will always be whether there was a factor recognized in psychiatry or in the human sciences that could be said to affect the legs of capacity. Does that help? Okay.
Yes. Thank you so much, Prof.
Okay, please mute your mic. I see Lituma.
Yes, Mr. Ramosa, I'm unmuted now.
Yes, continue.
Yes, I just need to go regarding the recent case of Julius Malema and Ndlozi, when they allegedly assaulted a police officer who prevented them access at Winnie Madikizela Mandela's funeral. I think apparently the charge is something an assault on the police officer, but now I think they see they prevented access, and while they were still mourning Winnie's death. So will they rely on NPCI for their defense, something like that?
All right. The charge would be assault. I don't think they can rely on being provoked to say that they couldn't control themselves in assaulting the police officer. That will be an impossible try, really. I don't think they can rely on NPCI.
All right.
Yeah,
because I was looking at the state of their emotions at the time when they were provoked.
No, in fact, it's more likely that that will just prove that they had capacity. All right. Thank you, everyone. Let's end the lecture here. Enjoy your day.